Former Lord Mayor Arias Lukwago was brought to the High Court by present authorities. Shortly after his arrival, news emerged that proceedings would be conducted in the judge's chambers, where only the sureties and fewer than 5 journalists were permitted to attend. After nearly an hour of waiting, it was revealed that Lukwago would spend at least 6 more days in prison before the court determines whether he will be granted bail. Among the sureties presented were politicians Betty Namboze, former Member of Parliament Lulume Baiga, and Lukwago's biological brother. The court later directed the defense to file its submissions by close of business Friday, while the prosecution will be required to submit theirs by Tuesday, 28th July, with rejoinders from the defense expected on the same day. During the proceedings in the chambers, Lukwago presented a collection of his medication and explained that the prison routine makes it difficult for him to follow his prescribed medical schedule, which requires him to take small portions of food at frequent intervals alongside his medication.
I'm predisposed, my lord, to TB infection because almost on a daily basis there are TB cases which are established. I was advised by our resident doctor that I should keep my mask on 24/7, but my lord, it's not easy. You can't sleep in a mask. And also, my lord, given my pulmonary challenges.
Lukwago further asked court to allow him access to medical treatment at Mulago Hospital once again, citing worsening health.
I'm worried because I'm sitting on a time bomb, my lord. I'm extremely worried. I'm having sleepless nights, my lord. Even the clonazepam, the bromazepam I'm using as sedatives, they are no longer effective.
As Lukwago awaits his fate on 30th July, his earlier bail denied by the Makindi Magistrates Court highlighted factors, including his influence in society and the weight charges against him, which the court considered. According to his indictment assigned by the Assistant Director of Public Prosecution, Thomas Jetiko, Lukwago is accused of failing to report information relating to an alleged plot to overthrow the government of Uganda between 2021 and November 2024.
Hopefully, we will get there. He will reach there. So, I did apply to go to Mulago, but court did not make those orders, but asked the prison's authorities, one, to do what is required in the circumstances after consulting the medical team in Luzira. So we will follow up with them to ensure that he gets the facilities that he needs, especially those that were recommended.
Now, the Electoral Commission has issued a stern warning to its election officials, particularly those deployed at the village level, against engaging in electoral malpractice, including tampering with voters' register, saying anyone found culpable will face the full force of the law. The warning follows allegations that some polling officials altered village voters' registers during Thursday's Women Council elections. The Commission says it has already received reports implicating some of its staff.
As the dust settles over the Thursday Women Council elections, it has emerged that some election officials at the grassroots were engaged in election malpractice. This resulted in the suspension of voting in some places or failing to take place altogether in some areas. Among the major concerns raised were alleged alterations of voter registers and the participation of individuals who were not eligible to vote. These incidents have heightened anxiety among candidates preparing for the next week's LHC1 chairperson elections.
The registrar would read the name, and then you find that 2 people are entering at the same time.
So it's very shocking that in some areas, not only the voters were missing from the voters' register, but even the candidates.
The Electoral Commission says it is fully aware of the reported irregularities, noting that some of its own officials have been accused of manipulating voters' registers, an act that disrupted the electoral process in some polling stations.
The Commission has started receiving some reports that some village election officials are tampering with the voters' registers. The Commission wants to send a warning to all village election officials and all actors that are trying to collude with these officials that interfering with the village voters' registers is an electoral offense.
As a result, several candidates urged residents to remain vigilant, warning that failure to defend the integrity of the electoral process should have long-term consequences.
Most especially those ones who are contesting for the position of chairman, that you have to be very keen.
Call upon the government to introduce the biometric voter verification system to these ground levels so that we can do away with the chaos and the conflicts, the disputes that arise due to the inconsistencies of the voters' register.
Despite the setbacks, the Electoral Commission says the challenges encountered have provided important lessons ahead of the LC1 chairperson elections, adding that collective measures are already being implemented. The Commission has also warned its officials that any staff member found to have manipulated voters' registers or interfered with the credibility of the elections will face disciplinary and legal action.
Act with integrity. Do not be tempted to interfere, to manipulate the voters' register, because the voters' register is a credible voter register, is the foundation of a credible election.
The LC1 chairperson elections are scheduled for July 28th, while women council elections will continue at the parish level.
Now, local leaders, civil society actors and political analysts across Mbarara district and Mbarara city are raising alarms over the declining authority of office of the local council 1 chairperson, warning that the bedrock of grassroots administration is rapidly losing its purpose. Conceived as a community-driven forum for local arbitration, security, coordination and participatory governance, stakeholders say the office has largely degenerated into a transactional post.
The Local Council 1 or LC1 system, originally introduced as Resistance Council's RC1 during the 1981-1986 Bush War, formally established nationwide in 1987, was renamed local councils under the 1995 Constitution. Strong as they were, 4 decades later, many say, the position has been weakened, with residents living in areas without knowing who their LC1 chairperson is, but also lost trust in the office.
LC1 leaders are no longer relevant. In fact, to me, they should be scrapped, because they are no longer working for the people, they are no longer working for Ugandans, they are working as brokers of politics.
In many cells and villages across Mbarara city today, candidates actively seek election primarily to take custody of the official village stamp, a lucrative instrument used to charge fees for land transactions, verify legal documents, and validate commercial deals.
In fact, if you want to know that they are no longer relevant, you see the land grabbers, they use LC1s. If you go to court, the problem we have at court about those cases are increasing because of poor leadership from LC1, because you cannot sign an agreement to 2 people, 3 people, and you sell land more than 1 time.
Those ones who are incoming with hope that there is trade in a stamp, I think they are wrongly informed. These stamps are to be done for the service of our villages. It is not a trade of its own.
Political analysts in the region attribute this shift to political interference and a weakening rule of law at local level rather than resolving conflict through grassroots consensus and local council courts.
In fact, they should be scrapped and we use the appointed leaders. For example, the Muruka chief, the Gomborora chief, the RDCs, at least for them, they are working.
Many residents relocate to new areas and no registration takes place, which was never the case. These now bypass traditional channels, relying instead on personal ties with local enforcement agencies. As a result, regular village council meetings, once essential for transparency, local accountability, and community decision-making, have almost completely ceased to exist.
The Parliamentary Committee on East African Affairs has resolved to prioritize the 4 pillars of integration as it embarks on its mandate in the 12th Parliament. In an interview, the committee chairperson Dennis Namara said the focus will be on the full implementation of the protocols on the Customs Union, Common Market, Monetary Union and a Political Federation.
Legislators on the Parliamentary Committee on East African Affairs have adopted their annual work plan for the year with a pledge to fast-track the 4 key pillars of regional integration.
We have come up with few areas where we're going to focus.
Speaking to NBS TV after a closed-door meeting, committee chairperson Dennis Namara said the committee will center its work in the first year of the 12th Parliament to implementing the Customs Union, Common Market, Monetary Union and Political Federation protocols.
How far are we with the implementation of the protocol on Customs Union? How far have we reached with the implementation and domestication of the protocol on Common Market? Where have we reached with the Monetary Union? What are the targets? What are the advantages? We're also looking at the issue of Political Federation.
The committee also resolved to tackle non-tariff barriers that continue to frustrate cross-border trade within the East African community. Infrastructure development is also high on the agenda, with members identifying the construction of the standard gauge railway from Mombasa through Malabar to Kampala as a priority project for the regional connectivity.
We're going to look at the regional infrastructure projects in the transport corridors, the northern corridor and the southern corridor. How far with the standard gauge railway from Mombasa up to Malabar, up to Kampala? How far with the oil pipeline? How far have we reached with it? So we're going to look at infrastructure projects that facilitate trade within East Africa.
The committee further expressed concerns over delayed payment of the subscriptions by several East African community member states, noting that the shortfalls are affecting the operations of regional institutions.
The community is limping because of non-remittance from most of the partner states, but Uganda, good enough, is remitting. So we want to have an interaction with the committees of other partner states in Kenya, Tanzania, Rwanda on East African integration.
In addition, the committee plans to strengthen collaboration with regional bodies including COMESA and the East African Legislative Assembly to deepen integration and harmonize policies.
Let's speak some Latin, habeas corpus. Now, as political parties continue demanding answers of members whose whereabouts remain largely unclear and unknown, legal experts are questioning who bears the responsibility when the state denies holding a person, especially if that person is missing. They say that while the law provides mechanisms such as habeas corpus to compel authorities to account for individuals, questions linger and remain over whether existing safeguards are sufficient to close accountability gaps.
Article 23, Clause 9 of the Constitution grants every person the right to apply to the High Court for a writ of habeas corpus, requiring authorities suspected of holding an individual to produce them before court, whether alive or dead. But when security agencies deny holding a person reported missing, who takes responsibility for establishing their whereabouts? Over the years, several Ugandans have disappeared under unclear circumstances, with the police, military and the Attorney General at times denying knowledge of their whereabouts. Similar concerns have been raised in the cases of Muhammad Mwanga Kivumbi, Muhammad Kanatta, John Bosco Chibalama, Sam Mugumya and others, as their families and political parties continue seeking answers. Lawyer Abdallah Chiwanuka, who has represented families of missing persons, says even while it is unclear who is responsible for a disappearance, the obligation to account for the individual remains with the government.
At any given moment, you must be known where you are. The government must know where I am right now. Even if you don't know who abducted them, it is the government responsible.
Chiwanuka says families of missing persons have a right to seek legal redress, arguing that the state has a constitutional duty to protect people and their property.
And all the relatives of the affected or the people who were abducted are at liberty to take on the government to court in civil matters, to implicate them so that they can be compensated.
However, does the denial of custody by state agencies create a gap that can make accountability difficult? Lawyer Samuel Muyezi, who is part of Muhammad Mwanga Kivumbi's legal team, says habeas corpus applications require urgent determination because they directly concern a person's liberty and safety, though another precedent has been set.
I believe we are going backwards. You will not envisage a situation where you file a habeas corpus application, for example, like the one we filed for the Honorable Mwanga Kivumbi on the 14th of July. It was fixed for 17th, and we are still in court without a decision of court, where court in a way is at the mercy of the state.
The lawyers argue that in Kivumbi's case, police acknowledged intercepting him but later denied holding him or knowing his whereabouts. They contend that once a person is intercepted by security agencies, authorities should account for what happens to him.
In a situation where people are abducted, even during day, and the government says even where people who are abducting people, they are holding guns, that is a clear indication that the government is involved.
Because having considered that you apprehended a person, then the duty is yours to bring that person to court. You do not need a court decision for you to make further investigations.
The lawyers maintain that once court orders are served on relevant authorities, including police, military leadership, and the Attorney General, their legroom in the law ends. They add that challenges often arise when cases involve political actors.
Such a scenario where people are abducted and their whereabouts are unknown, our limitation stops at the point of the writ.
But we cannot stretch it further than having orders from court. Ours and the duty and obligation is to ensure that we get court orders.